Yeah, let's go ahead.
Okay, so good evening, guys. Today we are going to start a new topic, which is love jihad laws and the relation of fundamental rights with the new laws passed by the UP government and other states also. So, for discussing love jihad laws, we should have the knowledge of love jihad, the concept of love jihad, what actually love jihad is. So now coming to the first part of the PPT. So Indian society is divided in two parts on the concept of love jihad. So the first division of the society says that love jihad is a conspiracy by Muslim men to convert non-Muslim women, particularly Hindu women, under the pretext of love, under the pretext of marriage. And those who subscribe to this view, means the first group, and the persons of first group who subscribe to this view believe that marriage for conversion or conversion for marriage, so either conversion before marriage or after marriage, both should be made illegal. Now, now we can come to the second point, means second group's view. Now the second group claims that there is no such thing as jihad and love. Love is pure, and there is no organized attempt by any group of individuals to entice girls, women belonging to Hindu or Christian religions to marry Muslim boys with the aim of converting them to Islam. And they also claim that the concept of love jihad is like a Loch Ness monster. So, uh, does anybody know what a Loch Ness, what a theory of Loch Ness monster, or what actually a Loch Ness monster is? Does anybody want to answer for this?
Sir, it's a mythical creature in Scotland.
Yeah. Okay. So, great answer. So the Loch Ness monster, some people claim, means we can say some people in the world or a group claim that it's a monstrous animal which is found in Scotland. So nobody has seen the animal, and there is no evidence that there is such an animal. But then also the concept of a Loch Ness monster is inside the mind of people. It's just an ideology. So just like Loch Ness monster, there's a concept of love jihad. It's only in the mind of people. There's no evidentiary proof of love jihad. This is the claim of second group. Okay, so these are the two concepts of love jihad. So is there any problem with the concept of love jihad? If there's not no problem, then we can move further.
It's clear, sir.
Okay, so let's discuss from the point in which case the concept of love jihad highly emerged. As mm, as love jihad has emerged in 1927 in India. It's a word which came into view in 1927, but it's not relevant how it came in 1927, because we have to discuss the landmark cases of love jihad and in which cases the love jihad has emerged as a concept, and everybody in India came to know what love jihad is. So there's a case, Hadiya case, commonly known as Hadiya case, which is then in 2017. In this case, there was a Hindu girl, Akhila, who got married to a Muslim boy, Safin Jahan, and then converted into Islam and changed her name to Hadiya. So the father of the girl was against the marriage and conversion, and so he approached the Kerala High Court and said that this is a classic example of love jihad, as my daughter was seduced and lured for the conversion. The father gave the reason that his daughter is not it's not the willingness of a daughter to change into Islam. It's because of the seduction and because of the allurement that Safin Jahan uh, has, by the means of allurement and by the means of seduction, Safin Jahan has converted his daughter. So Kerala High Court annulled the marriage. Further, the matter went to Supreme Court, and Supreme Court said something very significant in this matter. This made the base for all the marriages. Further, Supreme Court stated that Article 21, which is right to life and personal liberty, also include right to marry. We know that there's under right to life and personal liberty, there are many other rights such as right to dignity, right to clean environment, right to clean water. There are many other rights, and among these other rights, there is also a right to marry, which is related to right to life and right to personal liberty. Means we can't assume right to life and personal liberty without including right to marry in it. Okay, And right to marriage, basically the freedom to choose your life partner. And it's also fundamental, right? Now, ultimately, Supreme Court has allowed the Hadiya to go with her husband on the basis of this judgment which Supreme Court had given. So, any problem with Hadiya case, or should we move further?
Sir, it's clear.
Okay. So, after Hadiya case, there are many instances at which Supreme Court has reiterated the judgment given in Hadiya case. So, in one of its own judgment, Supreme Court stated that marriage is an extremely personal affair. The right to marry a person of one's choice or to choose one's partner is an aspect of constitutional liberty as well as privacy. The fundamental right to privacy protects an individual's ability to make choices and decisions that are intimate. Now, after that, see, in the first point, Supreme Court has given an aspect of privacy also, which is related to the marriage. Now, in second point, during hearing a case of privacy judgment, a 9-judge bench of Supreme Court upholding the fundamental right to privacy had clearly said in 2017 that it is upon an individual on how one wants to exercise one's freedom to make those personal choices. Whether one's partner would be of the same faith or not is a private decision. The way of life an individual wants to pursue after marriage is again a right of personal choices. Means the Supreme Court also included uh, right to marriage and right to choose partner as a private right. Means now that's for an example, let's take an example. Now, if a person is going to marry someone, the person doesn't have to disclose it to anyone whom the person is going to marry. Even it's not the duty of the person to disclose it in front of his or her parents, because it can be a moral duty to disclose about the spouse in front of parents, but it's not a legal duty. And Supreme Court clearly stated that it's not a legal duty, it's your intimate uh, it's your private thing. So you can, so everybody has a person to live its privacy. So whether one's partner would be of the same faith or not is a private decision. And the way of life an individual wants to pursue after marriage is again a right of personal choices. And it also gets its support from the right to privacy. Okay. Now, moving on to the next slide. What happened in 2020? A single judge bench of Allahabad High Court stated that conversion just for the purpose of marriage is unacceptable. After this verdict of High Court, what happened? UP government has passed uh, a law which is known as Anti-Conversion Ordinance. The real name of the law is the Uttar Pradesh Prohibition of Unlawful Conversion of Religion Ordinance 2020. This verdict has supported, this single judge bench of Allahabad High Court verdict has supported the ordinance. That's why the Uttar Pradesh government has made the ordinance. Now, moving on to the provisions, what the provisions in the ordinance. So this one second. Yeah. So this UP anti-conversion ordinance has certain provisions, has certain punishments defined under 3 heads. So the first punishment is to those persons who are found guilty of conversion through misrepresentation, force, undue influence, coercion, allurement, or by any fraudulent means, or by marriage. See, the term marriage has been highlighted by the single judge bench of Allahabad High Court. That's why they also included, the government of Uttar Pradesh also included the term marriage in the provisions in the ordinance. So, if anybody is found facilitating the conversion by the means of misrepresentation, force, undue influence, coercion, allurement, or by any fraudulent means, or by marriage in contravention to the law, then the person would face jail term of 1 to 5 years and a minimum fine of 15,000. This is the first head of punishment. Coming to the second head of punishment, in the second head of punishments, the the ordinance prescribes 3 or 4 type of people or type of human beings on which there would be much punishment if somebody is facilitating the conversion of those kind of humans. So in second head of punishment, if the conversion is of a minor, a woman from the scheduled caste or from the scheduled tribe, then those found guilty of facilitating the conversion would have to face a jail term from 3 to 10 years with a minimum fine of 25,000. Now, coming to the third head of punishment, third head of punishment talks about mass level conversion. So those who facilitates mass level conversion by the means of misrepresentation, force, undue influence, coercion, allurement, or by any fraudulent means or by marriage would face jail term of 3 to 10 years with a minimum fine of 50,000. These are the three heads under which punishments are provided in the ordinance. Now, coming to the fourth point states that if any person reconverts to his or immediate previous religion, the same shall not be deemed to be a conversion under this ordinance. So let's take an example to understand this. Suppose a person is Sikh and then the person converts into Islam. And after he converts into Islam, this ordinance came. And then someone facilitated the conversion of that Islam, a person who has converted into Islam, into again into Sikh religion. Then the facilitator who has facilitated the conversion would not be liable for the same thing, because it's clearly stated in the act that if any person reconverts to his or immediate previous religion, the same shall not be deemed to be a conversion under this ordinance. Okay, is this much clear?
Yes, sir.
Okay, so moving on to other provisions. So there should be a question in all of your mind that what will happen if a person wants to convert willingly, if a person wants to convert voluntarily, then what the person has to do to prevent himself from getting punished under the provisions of this ordinance. So if anybody wants to convert willingly into another religion, then the person would have to give it in writing to the district magistrate at least 60 days in advance. And the religious converter who is going to facilitate the conversion, who is going to perform the conversion ceremony, has to give 1 month's advance notice to the uh, district magistrate. Now, the government is supposed to prepare a format for the application, and the individual has to fill the application for conversion in that format. So, what will happen once the person fills the notice and provides it to the district magistrate? Then district magistrate uh, district magistrate post the notice at any conspicuous places so that everybody can read the notice. And after that, the district magistrate invites the objection. If anybody has the objection from the conversion, then he invites the objection, and if there is any objection, then the person who is going to convert would have to answer those objections with and he has to prove, the person who is going to convert has to prove that he is converting willingly. Now, and one more thing, the burden of proof as to whether a religious conversion was not affected through misrepresentation, force, undue influence, coercion, allurement, or by any fraudulent means or by marriage lies on the person who has caused the conversion. So suppose there is one trial, and in the trial somebody has accused the person that he has been converted by the means of misrepresentation, force, undue influence, coercion, allurement, or by any fraudulent means or by marriage. Then now it's the burden of proof will lie on the facilitator who has facilitated the conversion to prove that the person who has converted on at his own will. Okay, this much is clear.
Yes, sir.
Okay, so this is the total summary of all the provisions in the ordinance. As we have already discussed, a person has to submit a 60 days notice to the district magistrate, the person who is going to convert, and the person who is going to facilitate the conversion has to give a 30 days notice to the district magistrate. After that, district magistrate will institute a police inquiry. Now the notice will be publicly exhibited for any objections. If there is, now one more thing, the converted person has to appear before the DM and confirm his identity and details. Okay, we have also discussed the punishment. Clearly under three heads. Now, after that, the burden of proof that a conversion did not happen through force, fraud, or marriage rests on the person who facilitated it. And second last thing is marriage done for the sole purpose of religious conversion are liable to be declared void, because the as it got its support from the single judge bench of Allahabad High Court. And last point is that all offences under the UP law are non-bailable. Okay. Now I have completed all the provisions of the ordinance. Is everything clear now?
Yes, sir.
Yes, sir. So, sir, I missed the first 10 minutes. Can I please get a recap? I had a power cut here.
Okay. So first 10 minutes you missed, huh?
Yes, sir.
So in the first 10 minutes, we have discussed the concept of love jihad. So there are two kinds of group. So there are two types of group in the Indian society. As per the first group, the love jihad is a conspiracy by Muslim men to convert non-Muslim women, and particularly Hindu women, under the pretext of love. And those who subscribe to this view believe that marriage for conversion or conversion for marriage, that's conversion before marriage or after marriage, both should be made illegal. The second type of group states and claims that there is no such jihad, there is no such concept of jihad and love, because love is pure. And then there is no organized attempt by any group of individuals to entice girls, women belonging to Hindu or Christian religion to marry Muslim boys, uh, with the aim of converting them to Islam. And the concept of love jihad is just like a Loch Ness monster, as Loch Ness monster is believed to be a monster, which is in the Scotland, but there is no evidentiary proof of that monster. So there's no. So the second group claims that there is no evidentiary proof of love jihad, and love jihad is only in the mind. Now coming to the Hadiya case, there is one girl Akila who got married to a Muslim boy Safin Jahan, and then she got converted into Islam and changed her name to Hadiya. So the father of girl was against the marriage and conversion, and he approached the Kerala High Court and said that this is a classic example of love jihad, as my daughter was seduced and lured for conversion. So Kerala High Court annulled the marriage, and then finally matter went to Supreme Court. So Supreme Court said very significant and stated that Article 21 also includes right to marry. Among other rights, that's Article 21 also includes right to dignity, right to clean environment, and right to clean water. So just as this, that Article 21 also includes right to marry, that is freedom to choose your life partner, is also fundamental right. And ultimately Supreme Court allowed Hadiya to go with her husband. And then we have discussed the Supreme Court's position after Hadiya case. We have discussed how right to privacy also tells us that marriage is a private thing. So it has also supported right to marry being a fundamental right in this. Moving on to next thing, after Hadiya case in 2020, what happened? A single judge bench of Allahabad High Court stated that conversion just for the purpose of marriage is unacceptable. And then this became the base for the UP government to pass an act and law, which is UP Anti-Conversion Ordinance, and its official name is the Uttar Pradesh Prohibition of Unlawful Conversion of Religion Ordinance 2020. So after this also you missed?
No, sir.
So I have a doubt. It's a
Yeah.
very small doubt. So this law is only in UP, like only for UP?
Yeah. We are going to come. We are coming on this point. Okay.
Oh, okay. Thank you.
Okay. So after summarizing all the provisions in the ordinance, this is the list which you are asking for. So there are many Indian states who had passed a law against religious conversion. In 1967, Odisha was the first Indian state to pass a law against religious conversion, the Freedom of Religion Act, which has similar provisions. Madhya Pradesh followed with its own anti-conversion law in 1968. Then Arunachal Pradesh. Then in 2002, Tamil Nadu passed the Tamil Nadu Prohibition of Forcible Conversions Act, primarily directed at Christian missionaries. After that, Uttarakhand under Chief Minister Trivendra Singh Rawat bought a similar law, Uttarakhand Freedom of Religion Act 2018. Then Himachal Pradesh. Okay, is
So
it clear
all
now?
of their, I'm sorry to interrupt, all of their contents are also more or less different? Like it's not like exactly the same, right?
They are 80 to 90% same.
Okay.
Yeah, because see, the main point is that all the laws are prohibiting conversion only, and when they are prohibiting conversion, they can't be particularly against one religion, because India is a secular country. So any state government or central government can't be particularly clearly can't be against any particular religion. So all the laws are against conversion, and so all has a similar provisions. Okay.
Yeah, okay. Thank you.
Yeah. Moving on to next slide. So we are coming now on what's the role of fundamental rights. So there are two rights which are coming into role if we are talking about love jihad. Then first right is of Article 21. Then Article 21 states that right to life and personal liberty, and as we know by the judgment also by the Hadiya case, that it also include right to marry, that is freedom to choose your life partner, is also a fundamental right. Now it's also supported by right to privacy. after that, Article 25. So Article 25 here is important, and Article 25 states that subject to public order, morality, and health, and to the other provisions of this part, all persons are equally entitled to freedom of conscience and the right to freely profess, practice, and propagate religion. So I have highlighted also, I have broken it into two parts because Article 25 is a twofold right. And it's very important to understand Article 25 because it can be in the passages and the questions, you have to solve the questions on the basis of passages only. So if you have a clear knowledge of Article 25, then it will be easy for you to grasp the thing which is written in the passage and then solve the question. So Article 25 is a twofold right. First, it gives you freedom of conscience. What is conscience? So suppose you are a person, you don't want to associate yourself with any religion. You want to be atheist. You want to be agnostic. Then then freedom of conscience gives you the freedom to be atheist and freedom to be agnostic. Because freedom of conscience also gives you reason to be in a religion, or also gives you freedom to be away from the religion. Okay. And after that, if you have chosen to be in a religion, to get associated with a particular religion, then the next rights come, which gives you the right to freely profess, practice, and propagate that particular religion whom you are associated with whom you are associated with. Okay. So, and this right is subject to public order, morality, and health. Is it clear till now?
Yes, sir.
Yes, sir.
Okay. Now, moving on to the last part of this PPT, it's Allahabad High Court decision in 2020. So, in this case, there is a lady, Priyanka Kharwar, and she married Salamat, Muslim man. So, there's a case of love jihad. Mm, As in the Hadiya case, the Hadiya's father objected. In this case, similarly, Priyanka Kharwar's father objected on this at this marriage. So what Allahabad High Court said is very significant. Allahabad High Court stated that we don't see Priyanka Kharwar and Salamat as Hindu and Muslim. They see it. They see them as rather as two grown-up individuals who out of their own free will and choice are living together peacefully and happily. The courts and the constitutional courts in particular are enjoined to uphold the life and liberty of an individual guaranteed under Article 21 of Constitution of India, and right to live with a person of his her choice irrespective of religion professed by them is intrinsic to right to life and personal liberty. Now, it's very clear that the condition of marriage as an annulment of the conversion, because marriage can't be a sole reason for the conversion. This Allahabad High Court single bench has stated in 2017, and after that UP government has passed the law supported by that particular government. So recently, after passing the law, Allahabad High Court gave this judgment in 2020, which states that we don't see Priyanka Kharwar and Salamat as Hindu and Muslim, rather as two grown-up individuals who out of their own free will and choice are living together peacefully and happily. So Allahabad High Court indirectly said that it doesn't matter to them whether Priyanka Kharwar is Hindu or Muslim, and if she is Hindu and then she converts into Islam, Allahabad High Court has no problem off from the Priyanka Kharwar's converting into Islam, because she is free, she has the freedom to convert, and Allahabad High Court is not going to interfere in the matter till the conversion is voluntarily. Okay. So this all is the Allahabad High Court suggested in 2020s, and this is against the UP ordinance. So further, what will happen? It will be a matter of current affairs, and we will discuss what will happen. Okay.
Yes, sir.
So now coming to the legal questions related to Article 9, this 21 and 25. There is the first question for you. Solve it in 3-4 minutes, and then we will discuss it. So Gargi, please choose the best one between D or A. And Nagalakshmi also, please choose the best one between D or B. Okay, so I think we should start discussing this question. So this question starts, the passage of the question starts with the mentioning of Article 25 of Constitution, which guarantee freedom to religion to all persons in India. Then it provides that all persons in India are subject to public order, morality, health, and other provisions. We have discussed that these are subjects under which Article 25 can be restricted. The subjects are public order, morality, health, and other provisions. Okay. Then are equally entitled to freedom of conscience, every person in India, and have the right to freely profess, practice, and propagate religion. So it's a twofold right. First, freedom of conscience, and second one is right to freely profess, practice, and propagate religion. Now, it further provides that this article shall not affect any existing law and shall not prevent the state from making any law relating to so regulation of restriction of any economy, financial, political, or any secular activity associated with religious practice, providing social welfare and reform, opening of Hindu religion institution of public character for all the classes and sections of the Hindus. Then the facts are like three children belonging to a particular sect, which is Jehovah's Witness, worshipped only Jehovah, that's the creator, and refused to sing the national anthem Jan Gan Man during their school's morning session. Then, according to these children, singing Jan Gan Man was against the tenets of their religious faith, and they believed their religious faith, okay, which did not allow them to sing the national anthem. These children stood up respectfully in silence daily for the national anthem, but refused to sing because of their honest belief. Except these three children, whole school participated in singing national anthem. Then the headmistress of school expelled these three children for not singing national anthem. The action of headmistress is, so some of you has mentioned D, and then B also, A also. Okay, so we will check each and every option. The first option suggests that violative of the right to religion of three children, the yeah, as religion is primary and nation is secondary as per the constitution itself. There is nowhere written in the constitution that religion is primary and nation is secondary. By Article 25, if constitution guarantees freedom to religion to all the persons in India, if it provides that all the person in India subject to public order, morality, health, and other provisions, if are equally entitled to freedom of conscience and have the right to freely profess and practice and propagate religion, this doesn't mean that religion is primary and nation is secondary. Nowhere there is written in the constitution. So first option is wrong. Coming to the B option. B option is not violative of right to religion, as nation is primary and religion is secondary. Nowhere there is mentioned either in the principle or in the constitution that nation is primary and religion is secondary. So this is also wrong. Option B is wrong. Coming to option C. Option C states that action is great. So okay, applauding the action. Option C is applauding the action. And the reason is that because people of such kind should be expelled from country too. So I have um, told you in yesterday's class that such kind of suggestions are not invited. So this is wrong option C. And there is nowhere mentioned in the passage also that such kind of people should be expelled from the country. So it's not relating to the passage. Coming to the option D. Option D is the last option, so it must be the correct option. And option D is violative of right to religion of these children, as no provision states that a person showing respect to national anthem must sing it. Yeah, many of us in the schools have not sung the national anthem, but many of us have stood up while national anthem is going on. So there's nowhere written that for showing respect to national anthem you have to sing it. There's nowhere written. So it's violative of right to religion of these children, as it is clearly mentioned in the question also that these children stood up respectfully in silence daily for national anthem. So the question also is trying to tell you that the children are respectful towards the national anthem. Okay, so Is it clear? Is this question clear?
Yes, sir.
Yes,
sir.
So moving on to the next question. The passage is same, question is different. Do it in 3-4 minutes. We will discuss this. Okay. So we should discuss it. The passage is same, so I'm not going to discuss the passage because we know that Article 25 is a twofold right. First is the right to freedom of conscience, and second is the right to freely profess, practice, and propagate religion. But it is subject to certain conditions. That's first public order, morality, and health. Now the question states that a person Tom who professes a religion named Vatican started burning incense sticks made of chemicals which are highly poisonous and can cause severe lung problems. According to Tom, this will bring him grace of God. Okay, it's Tom's belief. Then the neighbors of Tom started having problems due to the smoke released from incense stick, and they requested Tom to stop burning them. Then Tom argued that he has a fundamental right to profess his religion. So all of you have marked the C option as the correct option. Let's check. So option A is Tom is wrong because only persons of some religion has right to profess their religion. No, every person residing in India has the right to profess, practice, and propagate his or her religion. So option A is wrong. Option B. So option B, coming to the option B. Option B suggests that Tom is correct because his neighbors were also practicing their religion, so they have no right to stop Tom. So though neighbors are practicing, but the practices of his neighbors is not against the public order, not against the morality, and not against the health of others. There's nowhere mentioned in the question that the practices of the neighbors of the Tom is also against the health, is also against the public order or the morality. So B option is also wrong. Coming to the C option, which all of you have marked, the option is Tom is wrong because though he has the right to practice his religion, he can't enjoy the right on the risk of others' health. Okay, this seems to be a right answer because Article 25 is subject to public order, morality, and health, and anybody can't exercise Article 25 if the practices if the practices are against public order, morality, health, and other provisions. Okay, so this seems to be the correct option. Coming to option D. Option D is Tom is correct because he is not forcing anyone to pray his God of Vatican. This is wrong. This is redundant option. So option C is the right one. Okay, is there any problem in this question?
No, sir.
Okay, moving on to the next question. So this also passage is same. Yeah, passage same. Okay, so there is one typo error. See, Jack, the brother of Tom, also follows elk religion. Okay, so come to the second line. He wants others also to join Vatican religion. At the place of Vatican, suppose it's elk religion. Vatican is the typing error, so there should be elk. Okay. Okay. So Jack is the brother of Tom. The passage is same, so I'm just reading the question. So there's one brother of Jack, one brother of Tom with Jack, and he follows elk religion. For him, the spiritual text of elk religion is best in the world and helps a person in his spiritual growth. Okay. He wants others also to join elk religion. For this purpose, he held one meeting in his house with his very close 14 friends of other religions and told them about his religion and his spiritual practices. Does this act of Jack of uh, of holding a meeting with his 14 of friends and informing them about his religion and spiritual practices, is this against the fundamental right, or is this in line with the fundamental right? This is the question. Coming on to the A option, all of you have marked the A option. So coming on to A option, yes, A option suggests that yes, because Jack has the right to propagate his religion until it is affecting public order, morality, and health. This seems right because this is saying the same thing which is written in the Article 25. Article 25 states that every person has the right to propagate his religion until it is affecting public order, morality, and health. So this is saying the same thing which is in the Article 25. Okay. So now coming to the option B, let's check this also. Option B states that no, because Jack is trying to convert his friends into his religion. Okay, he's not trying to convert because there is nothing mentioned in the passage. Nowhere mentioned in the passage that he's trying to convert. He's not forcing any of his friends. They are his close friends, and he's just telling them. It's just an informal way of telling his friends about his religion and about its spiritual practices. So B option is wrong. Come to the C option. The option states that yes, because Jack's religion is one alternative, and people should give their time to other religions also. So as we all know, this is a suggestion, and suggestions are most of the time not invited. So C option is wrong. And C option in the C option, there's nothing written which is in line with the passage also. So C option is wrong. Coming on to the D option. D option states that no, and these kinds of meetings should be banned in the country like India. This is also a suggestion, and nothing in the passage has been mentioned that this kind of meetings should be banned. So D option is also wrong. So A option is the right one. Okay, is this clear?
Yes, sir.
Yes, sir.
So in the last, I have again mentioned the answers. Mm, do have a look of it and then tell me if there is any problem. If you want to know something else about love, jihad, and other things, then we can discuss them and then we can end the meeting. If you think that I have missed something which you have read in the newspaper and or other places, so we can discuss.
No, sir.
Okay.
All the Supreme Courts and all the High Court judges were covered. So, as of what I read in newspaper.
Okay. So yeah, we can end the meeting. Yeah.
Thank you, Yash.
Thank you, sir.
Thank you.
Thank you, sir.